Hello, my name is Emily Johnson, and today, along with these two teddy bears, I'm going to attempt to tell you how you should be able to beat any junk debt collector in court. Please keep in mind, this is not legal advice. These are just some techniques that have worked for me and that I believe will work for you. So if you're interested, stick around because this video could save you thousands of dollars. All right. If you're still here, here we go. First and foremost, no collection agency on this planet has the right to sue you for anything, okay? They purchased your debt for pennies on the dollar, and they're looking to make a profit, okay? They want to sue you. The reason they are suing you is because they're trying to trick you into signing a contract with them. That's why they drag you into court, because they think you're going to get scared and capitulate, okay? Which is always a mistake to do because they have no right to sue you for anything, because 9 times out of 10, you never signed a contract with them. You only signed a contract with the original creditor, all right? So they don't have the right to sue you. Okay, so should you get a summons from the court or a letter of demand or a letter saying that your credit or your account has been placed with a collection agency such as Capital One, the bureaus, Pat Nolan Felix, just to name a few, LVMV Funding is also another one. But let's just say you get a letter from one of those companies, and it tells you that your account has been placed with them and you have 30 days to respond, okay? If you get a letter such as that, or if you get a letter from the court summoning you to court, you are going to answer both letters in the same manner. First and foremost, you are going to make a copy of the letters after you finished inscribing what I'm going to tell you to inscribe on them. You want to send a letter to the collection agency, a letter to the court if need be as well, and you want to keep a letter for yourself so that you have a record, okay? So the first thing you're going to put on this letter is the correct date, so they know when you address the letter and that they are receiving it back in a timely manner, usually about 30 days, okay? If you respond to the letter and put the date on it, you also want to put that you don't have a business relationship with them, so you won't be paying them anything because you never signed a contract with them. And that if you were sued in court, you will defend yourself. And this last one is very important. You want to tell them to please leave your credit alone. That will keep it off your credit report. What these companies are doing, the LVM Funding, the bureaus, Pat Nolan Felix, all these companies, what they are doing is called credit piracy, okay? And they are suing you based on what they think you don't know. It's technically really a scam because they don't have the right to sue you at all because you never signed a contract with them, right? And when you go to court, if you don't sign anything, they can't prove contract, and it should get kicked out, all right? But we'll talk more about that in a second. Okay, so you get a letter of demand. You answer it. You correctly date it. You say that we don't have a business relationship, so I won't be paying you. You also tell them to leave your credit alone, and if sued, you will defend yourself in court, okay? You send it back. About 2 weeks later, they're probably going to send you another one, another letter. particularly if you received the letter not from the court, but the letter that said, that indicated that your account had been placed with their offices, okay? And the reason they're doing that to check to see if you're paying attention. And if you don't answer that letter, they will likely be able to put themselves on your credit report as a collection agency. Or, yes, and when they do that, then they will require that you pay them, okay? But what you can do if you find yourself in that situation is you can often make a deal with these companies and ask them, what is the minimum amount that you're willing to accept? Because all they want is some money from you, because it wasn't their debt to begin with, okay? So the only company where you may have a real hard time doing that with is LVMV Funding, okay? They work really hard to get the amount that that was charged off, you know, and the penalties as well, okay? So with those guys in particular, LVMV Funding, you want to do everything that you can do to keep them off of your credit report. Also, Patanol and Felix is a really aggressive, abusive collection agency. So you have to be careful with them as well, but we'll talk more about that later. Okay? In addition to the letters that you send out at the appropriate time, you're going to also give them a call. I usually make my calls after hours so that it connects me to the answer machine of that collection agency. I give them my account number, the account number that's printed on the letter that they sent out only, not your actual credit card number, because a big secret that a lot of people don't know is that these collection agencies often don't know the full credit card number, okay? And I've asked different lawyers if they know what that is, or if they could show me a contract between me and them. And I haven't seen one yet that could. But the point is that they don't have your full account number usually, so don't give it to them. Whatever used to be, you know, just don't give it to them. Give them only the account number that they print on the demand letter or on the court paperwork. That's it. Okay, so you call up, you give them your account number, your first and last name, and you tell them that you're not signing anything because you don't have an agreement with them. If sued, you'll defend yourself in court, and to leave your credit alone. Okay? And in about 2 weeks, they'll send you another letter. I know we kind of covered this a little bit, but you answer that letter in the same way if it's a letter letting you know that your account has been placed with us. If you get a letter from the court, what you should do is you should answer that as well. Now, usually you'll get several pieces of court paperwork. What I would usually do is I would take I take a piece of paper that has the suing attorney's name and also attorney ID. I'd make a copy of that, dating it, and putting on there that I didn't sign a contract with this entity, and I will defend myself if I'm sued in court. And I also put on the court paperwork only that nothing will be signed in court, okay? So that at least once you send it in, there's a record that you're not going to sign anything in court. And of course, I always put, I told entity to leave my credit alone, as we never had a business relationship. And I send that back out to the collection agency. And you'll have multiple copies or multiple pages in the court paperwork. So you can send out one to the collection agency, and also another to the court. Okay? So you get to your first hearing. Okay? You got your summons and you're going to your first hearing. Okay. So what I recommend is that before you go to court, that you have some type of recording device with you, maybe on your cell phone, and you also have something to take pictures with, maybe also on your cell phone, or maybe you bring a separate recording device and you use your cell phone to take pictures. There is no expectation of privacy in public. So you should be able to take pictures of the court clerk and also the presenting lawyer for the side of the collection agency. The reason you want to do this is because you'll never get a second chance to possibly get a permanent record of what transpired in court. And sometimes you may find that you may need that record that you never made or created. So just create one, okay? The courts, they do frown on this. So before you go into the courtroom, at least have your recording device on and ready to go, okay? And then while you're in court, you want to ask the court clerk's name or her name, their name, and take a picture so you know who they are. And also the presenting attorney, you want to know their full name and also their attorney ID. Now, it is important to remember that the presenting attorney or the attorney that's present in the courtroom with you may be different from the suing attorney. So make sure you know if it is a different attorney, that they would also have a different name, first and last name, and also a different attorney number. Okay? You may have to ask that several times because 9 times out of 10, the person the presenting attorney is going to try to provide you with only the suing attorney's ID and possibly name, okay? That gives them, the presenting attorney or the attorney that's present, a little bit of anonymity and protection behind the collection agency, okay? So make sure you're asking everybody's name and their attorney ID, and you're asking the court clerk's name, full name, okay? Okay, now the way this should work generally is you're usually in front of a judge when you go into court, and they read off a bunch of names because they've sued a bunch of people at the same time for debt that isn't theirs. By the way, ladies and gentlemen, this is called credit piracy. They have no right to sue you, as previously stated. I'm sorry. Okay? They're doing this based on what they think you don't know, and they are trying to trick you into signing a contract with them. Okay? So, you'll be in front of a judge, or a judge will be in front of you, and they'll read a bunch of names. Sometimes there's a lot of people that show up to defend themselves, and sometimes there isn't. And when people don't show up to defend themselves, the court usually generally rules in the favor of the junk debt collector or the collection agency. Okay? So you have to show up to defend yourself. It's so important. Okay? So the judge will read off a bunch of names, and when they get to your name, you say your first and last name, and I'm here to defend myself. Okay? Now, they may stop at that point and, motion for you to go talk to the lawyer that's presenting the case so that he can try to trick you into an agreement. They're not going to tell you they're trying to trick you into an agreement, but that's what they're doing. But what will likely happen is they will read all of the list of names, and all those people that aren't there will get a judgment against them. And when the collection agency gets a judgment against you, what they can do is they can then go back to the court and call in that judgment, and a judgment can shut down your checking account. Okay? And you can have your wages garnished. Okay? So you don't want a judgment. It's just a tool to try to force you to pay. But remember, you don't owe them anything because you never signed a contract with them. Your contract was with Capital One or TD Bank or American Express or whomever, but not with a Jack Smith's collection agency or LVMV funding or the bureaus. You never signed a contract with them. Okay? So, after the names are read and the judge has rendered judgments against all that didn't show up, the lawyer is going to take you into a conference room, the lawyer for the collection agency, and he's going to attempt to make a deal with you. Okay? He may say things like, we represent Capital One, for example, or he may say that they are them, that they are the original creditor. It doesn't matter what he says. He's lying, okay? He's just trying to trick you into signing a contract with him. So it doesn't matter what he says. Think of it pretty much all as a lie, okay? And after they get your signature, by the way, they then take that contract that you didn't know you signed, and they present it to a judge, and they say, look, see, we have an agreement. This person signed a contract with me. When in actuality, what you may have thought you were signing was something as innocent as you're going to court, that you'll show up for court, okay? So when you get into court, you are not going to sign anything. Listen up, people. Heads up. This is paramount. You don't sign anything in court. The only thing that I will allow you to put your name on when you arrive at your courtroom is a printed sign-up sheet that you have arrived. If you are asked to sign something electronically, refuse. Say your first and last name and say you're here to defend yourself, because you cannot be sure what that signature means. And you can go ahead and tell the court that I'm not signing that because I can't be certain what that signature means. Okay? Protect your signature. That's the important thing here. Okay? So you go into the room with the attorney. He attempts to make a deal with you. He tries to get you to sign an agreement with him. You refuse. And he says, okay, let's go to trial. Okay, so you'll go back out and you'll sit on the bench And then the court clerk will attempt to do the same thing and get you to sign the same contract that the suing attorney for the collection agency is asking you to sign. Now, you can test this theory. The internal documents that you don't see, that they're trying to get you to sign, will say, for example, LVMV funding, we are the real owners of this debt. And it is that document that they are trying to get you to sign, both the court clerk and the attorney for the collection agency. Same document. The court clerk, on the other hand, may say stuff like, I really need your signature, or you're just signing that you're coming to court. See this as a lie, because it is. Okay? I happen to think that the court clerks have been incentivized. Maybe the employer says, or the court say, if you get more signatures, you'll get more shifts. Or maybe they're just bought off by the attorneys, okay? But it doesn't really matter what the case is. They're lying to you. Everyone in that courtroom is lying to you. Everyone in that courtroom, including the judges, the lawyers, the court clerks, they are all in on the scam, okay? They just don't tell you that they're in on the scam, okay? So the court clerk will say, okay, Ms. Johnson, I need your signature. And I stand right there before him and I go, I'm not giving you my signature. I'm not signing anything, as I don't know what that signature means. The court clerk may ask you several times, and so may the lawyer, by the way, but you have to say no every time. If they hassle you too long, like, you can let them ask you maybe one or two times. But then after that, you say, may I speak with a manager? And when the manager comes in, you tell the manager, you say, I asked the court clerk to put refuse to sign and hit enter. And they won't do that. Could you please do that for me? Okay? Or could you please instruct them to do that? Because I'm not signing anything, because I don't know what that signature means. Now, I'm going to tell you once again what that signature means. You are signing a contract with the collection agency, so that once that contract is signed, they then present it to a judge, and the judge rules against you because they see that you signed a contract with the collection agency. Okay? That is why it's imperative, once more, that you sign nothing. Okay? So you don't sign anything. Maybe you get a manager involved because the court clerk isn't listening to you. They're still trying to obtain a signature from you that you're not going to give them. Okay? So after that, after nothing is signed and you didn't sign anything, they should be able to give you your court date on the spot. Okay? Now, a week before your hearing in front of a judge, if you find yourself in front of a judge, or just do it anyway, a week before your actual trial, what you're going to do is you're going to call the court and see if your account or if your case is still moving forward. If they say it is, then you immediately get off the phone and you call your state attorney general's office. You give them the attorney's name, first and last name, and the attorney ID. And you want to do that for the suing attorney, which should be on your court documents, and also the attorney that's presenting the case in your particular court circuit. Okay? and you want to say, I've been sued by a collection agency. I went to court in the first hearing. I didn't sign anything and I didn't ask for a continuance, but my case is still moving forward. If your case is still moving forward and you didn't sign anything and you didn't ask for a continuance, what that most likely means is that the collection agency has forged your consent on court documents to get the case to trial. Because if you don't sign in the initial hearing, they have no case. It gets thrown out because they can't prove contract. So to keep from doing this, and the courts are aware that these collection agencies do this, and that's why I'm telling you about this, is they falsify court documents. So they forge your consent. So that is felony forgery of consent. And by the way, that is a crime. Okay? But you get off the phone immediately and you call your state attorney general's office. Let them know you've been sued by a collection agency or junk debt collector. Give them the attorney's names and attorney IDs and tell them you didn't sign anything and you didn't ask for a continuance, but your case is still moving forward. So you suspect that the collection agency might have falsified court documents and said that you wanted a continuance when you didn't. Okay? And the the Attorney General's office should handle it from there. Okay? But let's just say you find yourself in front of a judge. Anyway, the first thing I want you to say, should you find yourself in front of a judge during trial, is, "Good morning, Your Honor. I didn't sign any type of agreement with this collection agency, and I never asked for a continuance." Okay? So practice that before you go to court, because if you don't say that you didn't ask for a continuance, then the case will just move forward. Okay? Now, the judges and the lawyers both know that you don't have any type of business relationship with the collection agency. But this is all about money. So too many people are making money for anything to change right now. And that is why you have to protect yourself. Okay? So, during the trial, make sure you, again, have your recording device so that you get a permanent record of the case. And, you don't want to miss out on this opportunity in case you need to go back and dispute something. Okay? So make sure you have that on. Okay? Before you go into the courtroom. And then just say, "Your Honor, good morning. I'm asking that you please dismiss this case because I never signed any type of agreement with this entity, not in the first hearing, not ever, and I never asked for a continuance. Please dismiss this case." Okay? The case should get kicked out. Sometimes it doesn't, because everybody thinks that, you're the dumb one in the courtroom. And they don't think you know anything. And that's what they're preying on. But if for some reason it doesn't get kicked out and the judge does rule against you, you should have a certain amount of time to appeal the case. So make sure you know how long you have, usually about 21 days, okay? And what you're going to file an appeal on is the fact that your consent may have been forged, okay? But you can also check the paperwork. I suggest that you check the court paperwork through the portal, to see what's going on with your case. Because with some collection agencies, as discussed before, they will put on your court paperwork, if they don't think that you're going to voluntarily pay them, they'll put defendant asked for continuance, okay, when you didn't. So make sure you say, I didn't ask for a continuance, and I never signed any type of agreement with this entity, okay? Now, after the case is over, after you've done your appeals, if you need to do your appeal, then depending on how old the debt is, what's going to happen is the collection agency is going to then try to send that back to the original creditor. And what they're going to try to send you out is a cancellation of debt, or what they will send you out is a cancellation of debt. And they'll say, the cancellation of debt will say, if you pay this much, we'll take it off your credit report, or something to that magnitude, okay? But here's how you beat a cancellation of debt. Regardless of whether you usually file taxes with a tax professional, in the year that you get a cancellation of debt, you will and you should, because what your tax professional can file on your behalf after your tax return comes back, is called a 982 form. And it's kind of like an expungement. It allows you not to have to pay the debt, okay? Not all tax professionals know this, but you can tell them about it and they can look it up. So at the time of this video, that was the correct document to file, 982. In the future, that document may change, but there should be something out there to replace it, okay? Now, there are pros and cons to filing a 982. Mostly pros, but on occasion, if your debt is not really old, what the original creditor can do is take back the debt and charge it off again. So you won't have to pay it per se, but it could leave a black mark on your credit. Still, it's worth doing because companies like LVMV Funding, they are notorious for filing old debt, okay? And if the debt is too old, then they can't send it back to the original creditor. So nobody can send out a cancellation of debt because the debt is too old. All right. But that's how you beat a cancellation of debt. You file a 982 form after your taxes come back. And your tax professional can help you with that. So make sure that you're talking to someone and you're telling them that you need a 982 filed on your behalf because you received a cancellation of debt from the original creditor. Okay? So that is pretty much it, guys. That's all I have for you. I just wanted to let you know that you can always fight a collection agency, and you don't need a lawyer to do that. Basically, what a lawyer will do is, a defense lawyer, what they'll do is they'll see your debt, let's say it's $2,000. And what they'll do is they'll break that down and they'll sue for half. And if they win, you pay them. My way is better because you don't have to pay anyone. You just have to stand your ground. You have to say, no, I'm not signing. If you get a cancellation of debt, you take care of it by filing a 982 form against it, which will expunge the debt. And then you move on from there. All right. I'm not telling you guys not to pay your bills, but if you find yourself in a hard situation, these techniques will work for you. Okay. Don't let anyone tell you they don't work. I've tried them myself and they do. Please keep in mind, this is not legal advice. As I am not fit to make it, I am not a lawyer. But the lawyers won't tell you this because they're part of the system and they're making too much money off of what you don't know. Everyone is making too much money off of what you don't know. These are million-dollar companies, and they're basically, these collection agencies are basically just stealing money from poorly educated people, unfortunately, you know. Anyway, so that's all I have for you guys. God bless you. I wish you the best in all your cases. I hope you win. And if you did get something out of this video, please like and share as much as you would like, and hit and then come back and see what's new from time to time. Thank you for your time. God bless you. This is Emily Johnson signing off.